Next few minutes, we have more reaction and analysis around the legal aspects as well as the constitutional aspects of it. I'll be in conversation with Stanley Malemetja, who is an attorney who will be talking to me about that particular situation. In fact, I'm told that he's ready and on standby, and I can go straight to him before taking a break. Stanley, thank you for your time, and I appreciate your time this afternoon. Stanley, how big a moment, a testing moment for constitutional democracy, the rule of law, and all these values in South Africa? How big a moment is this?
Thank you very much for having me, Tulas. I think this is a very big moment for a constitutional democracy. Not only does it illustrate the supremacy of the Constitution, which is enshrined in Section 2 of the Constitution, but it also speaks to the instructive power of the rule of law, you know. So, and actually here, what we have seen is that we've just seen the former president sailing a sinking ship into the deep waters of, contempt, and he really had to drown. And we see that there are institutions of accountability which are still effective and, willing to shield and protect the rule of law and the Constitution.
So there's a lot being made, Stanley, around the issue that this was a split decision, 7 justices going with the majority that decided that this is contempt of court and it needs to be nipped in the bud by sending him to prison for 15 months, while 2 justices held a different view, not on the question of whether or not this was contempt of court, but on the question of remedy. What's your thinking around that conversation, knowing what you know about how these things work?
I mean, dissenting judgments or minority judgments are not a new thing in our jurisprudence, in our judicial jurisprudence. We've always seen this. It always shows a very clear-cutting picture when judges actually dissent and not just follow each other. Like, we don't have like this head following of what the present matter presents to them. But what we need to highlight that is important is that they dissent insofar as the sanction, the relevant sanction. The courts are in one, the judges are in one tune insofar as the contempt of court, is concerned. But when it comes to the sanction, that's where they sort of like, go in separate ways. And some of the dissenting judges rather were saying that the order should be rather cohesive, so that Jacob Zuma can still have his day in the commission. But then the majority judgment said, look, we can't have a cohesive order if this person deliberately just said that he's not going to present himself before the commission. And also, this is just showing a disrespect, to the Constitutional Court. Because what we need to remember is that a contempt of court application, it is not a party versus party type of application. It is actually party versus the court, type of application. And therefore, the court's authority needs to be rubber stamped, and we need to see that we still have institutions of accountability, still existing. Yeah. So the dissenting order really doesn't really shift a lot of the goalposts that we have here.
So one of the things I like about what you do, Stanley, is that in addition to being a specialist on issues around the right to freedom of assembly and the right to protest, one of the things you do is focus on jurisprudence, the cultures and traditions. And I see you smiling, and now I have to disclose that actually that's the module that you taught me. I suppose for the sake of completion, let me disclose that you did teach me that module. But where I'm going with this is that understanding what the court has said and done in context, in society, locate this judgment in its context in society, a populace that will be seeking to interpret what has come out from Braamfontein, some people who will be measuring it against the standard that we have set for ourselves in as far as the Constitution is concerned. Some who will be even asking, is this the democracy we signed up for? Is this the judiciary we signed up for? And you will start hearing cries of a judicial dictatorship. What's your broad thinking around those themes?
My broad thinking around this, Tulas, is that when we signed up for democracy, some of the commitments that we made to ourselves is that we are going to create an egalitarian society. And an egalitarian society is not only limited to the access of socio-economic rights. It also speaks to equality before the law. So here, that's why that's why this case is monumental. Is that now we see that actually people can be equal before the law, and actually we can receive equal treatment before the law. And it doesn't matter whether you were a former statesman or you were once in power, where you are found, to have transgressed the law. When we see the law, taking its course, then that's the more people have faith, in the judicial system, in the legal system as a whole, because, there's a lot of debates that, the legal system is so liberal that it doesn't cater for, those who are in the marginal lines or those who are, in the periphery. But now what we see here is that with this order, or this judgment, is that people can actually be equal before the law. And this speaks to one of the fundamental factors of a democratic society, which is an egalitarian system.
But does that understanding filter through, in your understanding, filter through to ordinary South Africans, some of whom are disgruntled by the day-to-day conduct of politics, the shenanigans that happen within the ruling party, the governing party, the ANC? That understanding that this is the system we signed up for, and therefore we need to bear true to it, does it filter through? Is it your sense that it is widely understood and accepted?
I don't think it is widely accepted. You'll also remember from our jurisprudence classes that one of the issues that, especially in a country like South Africa, where we still have people who do not, kind of like understand how the system works and the legal system as a whole, is that judgments in most cases are written in jargons, and therefore they are unable to filter through to the people on the ground. But I guess, with such media engagements where we see a judgment, a fresh judgment, and we unpack it immediately, I think we are also becoming part of that rolling wheel of making sure that what the system, the broad system, what it says, it actually goes and filters into people and, try to enhance some understanding. We need to appreciate that even at the highest court, there were different views about this matter already. So even in society, people will hold different views and for different reasons, and they will present their positions in ways, some ways will be acceptable or welcomed, and some ways will not be welcome. So I think we still have a fighting chance of trying to ensure that people actually understand how the system operates.
All right, I've got to thank you for your time and your insights. That's Stanley Malemetja there, who is an attorney weighing in on this decision and the judgment that has come through from the highest court in the land, the Constitutional Court, around former President Jacob Zuma. We'll have more analysis for you on the story throughout the day here on eNCA. It's one of those moments that bend the arc of history, doesn't it? A former president, once very powerful. And who can debate how powerful former President Jacob Zuma once was? He really was a powerful man at a particular point. At this point now, facing the real prospect of going to jail. In fact, it would take something extraordinary for him not to go to jail.